Assalamu alaikum and welcome to the free legal advice show from British Muslim TV. I am your host Riffat Hussain and I will be with you for the next hour answering your questions on any legal issues that you have arising. You can participate in this show in two ways, either by calling the landline number at the bottom of your screen and speaking to me live in the studio. Alternatively, if you prefer not to speak to me live in the studio, then you may wish to send a message to our WhatsApp group. Again, you see the number at the bottom of your screen. I will be starting today by providing you with some legal updates. Once I've done that, I will move on to answering your questions. Please do forgive me because there's always a lot of questions that come through and I'm not always able to get through all of them. If you are wanting your question answered, I would suggest that you send that through as early as possible with as much detail as you can provide within the question so that I can address that as quickly as possible for you and to avoid any disappointment if I can't get around to it. Now, with regards to legal updates, I wish to touch upon a scheme which is almost imminent. It's a youth mobility ballot scheme that was announced just before the Christmas break, and it's a ballot. So this ballot applies to nationals of Hong Kong, Japan, South Korea and Taiwan. And the way this ballot works is it's for individuals who are between the ages of 18 years and 30 years, that they are invited to enter the ballot. Essentially, they're required to submit their details and have the opportunity to be selected as part of this ballot. Now, the way this works is an individual would need to enter the ballot. If they are then successful, they would then make an application to enter the United Kingdom for work purposes. Again, back end of last year, the government did announce a similar scheme for Indian nationals, although there are no confirmed dates or further details in respect of that ballot. So again, keep updated in respect of that and keep checking back for more details. Anybody wishing to enter this ballot for the countries that are able to, you are required to submit your name in the subject line, name, date of birth and passport number. And there are dedicated email addresses depending on the country that you are applying from. Please also remember that this is a limited time only ballot. So the ballot will open on the 17th of January. It will close on the 19th of January. So again, if you are interested, please make sure that you have noted those deadlines and that you are ready to submit your details in line with the requirements there. There are further details on the Home Office website, along with the relevant email addresses if you are interested. So do put that, note that deadline and put that through. And as I say, for any Indian nationals who wish to take advantage of a similar scheme, keep checking back on the government website or keep updated in other ways just to see when that's launching and what the requirements of that scheme will be. Probably fairly similar to the existing one. But again, we await further announcements from the Home Office in regards to that. Before I move on to giving you some further information, I believe we do have a caller to our line. So I will take this call. Hello, assalamu alaikum. Hello, assalamu alaikum.
Yeah, hello, assalamu alaikum, sister.
Alaikum assalam, brother.
Yeah, sister, I got a question regarding my biometrics. So I have done my biometric last month on 15th of December.
Yes.
So I just want to know when I will receive the biometric card, please.
Okay, so brother, what type of application is it that you've made?
It was so I was asylum seeker, so I got the leave to remain.
So you were an asylum
Send me
seeker.
the fingerprint.
I beg your pardon. So you were an asylum seeker, and have you been granted refugee status?
Yeah.
Okay. When were you granted refugee status?
It was like on October.
So you were granted in October. You were then invited to enrol your biometrics in December, and you're wanting to know when you will receive your paperwork.
Yeah, I mean the card.
The biometric card, that's right. So, brother, usually what happens is when an application is successful, the Home Office staff will then proceed to carry out certain security checks, criminal checks, whether somebody's on a terrorist list, whether they have committed any crimes overseas, etc. And those checks, depending on where those checks are taking place and to what level, can take some time. On average, my experience is that from the grant of your status, particularly because there was a need to enrol your biometrics, it probably will take about another 3 weeks before you receive your biometric card. If you do not, at that point, you should contact the Home Office. Just another question for you, brother. Were your biometrics not enrolled whilst your application was pending?
I didn't get that.
Sorry. So when you went for your Home Office interview, did they not take your biometrics at that point?
No. So basically, the court has given me the leave to remain. So I went to the court. The judge has decided to give me leave to remain.
Okay. So with regards to the court allowed determinations, implementation of those can take anything up to 3 months, which again you're approaching anyway. And if you have been asked to enrol your biometrics, they're probably towards the final stages of granting that. So I would suggest maybe give them another couple of weeks. If you haven't heard anything, then contact the Home Office and try and find out what's happening and what the delay is.
Okay, because someone has been told me that it could take up to 6 months.
That's not my experience. It may be that somebody has taken up to 6 months, but my experience generally is that it's within 3 months.
Within 3 months, you should get your BIP.
Absolutely.
Yeah? Okay. Thank you very much.
Thank you very much for your call, brother. Thank you.
Thank you.
We have another caller on the line, so inshallah I will proceed to take that call. Hello, assalamu alaikum.
Assalamu alaikum.
Alaikum assalam.
My question is, I submitted my application form, include with my family.
Yes, brother.
With the Zambrano case. Submitted my application on, that was a paper application on 30th of June.
Mm-hmm.
So it's more than 6 months past.
Mm-hmm.
Today I ring them, they said, they haven't decided or it's still in a process.
Yes.
I want to know how long it takes and what should I do, because obviously I'm stuck. If I want to travel, I can't travel without obviously my documents.
That's right, brother. Unfortunately, these types of applications, particularly with the ones that were submitted so close to the deadline, are experiencing huge delays just because a lot of people did that. They waited until the deadline and the very last minute, and then the Home Office received hundreds of thousands of applications that need to be processed and got through. They have a different priority service, so that there'll be European nationals within that are applying for settled status. There'll be European nationals who are applying for pre-settled status. There'll also be family members, and then there'll be individuals like yourself who are applying under the Zambrano rules. And so the Home Office is trying to get through those. With regards to timeframes, I'm afraid the Home Office isn't providing any. And a lot of applications have been pending now for a significant period of time. There are still applications that were made a lot sooner than June of last year that are still pending and have been pending in certain circumstances over a year. The only thing you can do, unfortunately, is wait. If there is a need to travel urgently, you might need to contact the Home Office to see if they can provide you with your documents. If you are doing that, just make sure that doesn't withdraw your application. But yeah, at the moment, the only answer is you will need to wait, unfortunately, because there is a backlog and there is a delay, but they are working through those applications. Does that answer your question, brother?
One more thing.
Yes.
Since I did ask them because my sister is not feeling well, so I asked them I need to travel. They said if you can provide us some kind of a medical report,
Yes.
we might look at and send only your documents.
That's right.
Well, and then when you come back, you have to send us back again.
Yes, yes. So that there will be situations where people do need to travel urgently, and if you are able to provide medical evidence to say it's compassionate circumstances, then they may send your documents back. Again, just seek clarity that they're not withdrawing your application. They are just simply sending them back to facilitate your travel and then for you to return back. What status did you have prior to putting in this application, brother?
On 26th of June, I received my renewed BRP card. That was 10-year family route.
So you do have valid leave in the UK?
Yeah. That was obviously 26th of June. I received my BRP card, renewed one, and expiring on 23rd in 2023 in November.
Right.
So yeah, still there's a valid BRP card. Obviously, I can travel on this one.
Yeah, and I think the other thing that you might need to check as well, brother, is if you have valid leave and you make another application, are you cancelling the leave that you already have? Because that can have, a new application can have that effect. You're essentially changing the leave that you've got. So just double check that your 10-year route to settlement is actually still a valid form of leave that you hold, because you don't want to travel believing that you still have some form of status and then that isn't in place for you. So inshallah, check those details, but do communicate with the Home Office. But in terms of how long your application will be, I can't answer that question for you. But, again, keep in touch with the Home Office and they might be able to update you.
Okay, that's fine.
And thank you so much for taking the time to present your questions. Right, inshallah, that takes us towards our first break. So that's the end of the first segment. Inshallah, join me after this brief break and I will continue to provide further information and answer your questions. Assalamu alaikum and welcome back to the Free Legal Advice show on British Muslim TV. I am your host, Riffat Hussain. We are now into the second segment of this evening's show. May I say thank you very much for our brothers and sisters who have participated already in this programme and who continue to do so by sending your questions through onto our WhatsApp group, and also for your very lovely comments on Facebook. I'm glad you're enjoying the programme. Please do stay with us and hopefully I can provide you with some further guidance and enlightenment. I do have a number of questions through Facebook and inshallah I will turn to those now. The first question is, I am not working because of health conditions. I am on universal credit. My income is over £2,000. Do you think I can bring my partner from abroad by the law? So with regards to this question, it's a common question in immigration law. A British citizen or an individual settled in the United Kingdom marries overseas and then needs to satisfy a financial requirement for the purposes of the immigration rules. Ordinarily, that requirement is that the applicant can demonstrate either through their own income or through a combination of their income and their sponsor, the husband or wife in the UK, their income, that they are earning a gross amount of 18,600. So that's 18,600 before any tax is taken away. There are certain exemptions to that, and usually those exemptions apply to individuals who are on a low income due to incapacity, ill health, and who are then in receipt of certain benefits. Now, of those certain benefits, which are quite clearly listed within the immigration rules and Appendix FM as the relevant appendix which applies here, specify the benefits which will provide that exemption from meeting that financial requirement. It doesn't mean that the individual doesn't have a financial requirement to meet. There is a misconception that if an individual is in receipt of benefits, then there is no financial requirement, and that's not true. There is a financial requirement. It's just a different test to the 18,600 test that applies to an individual who is in employment or who is gainfully earning. So with regards to an individual who is not working or who is in receipt of public funds and benefits, universal credit doesn't count, unfortunately. You mentioned that you are not working due to health conditions. You will be able to use your income, your benefits income, and use that to satisfy the Home Office that you are able to support yourself and your partner if you are in receipt of personal independence payments, or if you are still on the predecessor of that, which is the disability living allowance. Carers allowance is another benefit that's named within the immigration rules. You're the ill person, so it's unlikely that you are receiving carers allowance to care for yourself. So if you can demonstrate that you are on any kind of disability benefits, so PIP, DLA, that combined with your universal credit income, you can then use. If you're not in receipt of PIP or disability living allowance, then I would highly recommend that you make inquiries about your eligibility. Not only for the purposes of inviting your partner to the UK, but you may be missing out on other support that you are entitled to. If you are in receipt of those benefits, then you can certainly invite your partner. That hopefully is the answer to your question. But that there is no bar on you applying for your partner to join you as long as you are receiving any illness-related, sickness-related benefits rather than just universal credit. The next question is, I'm on a 10-year partner route, which is the FLR-FP. 5 years have already 5 years already done. Now is the third time to renew. My question is, after 7.5 years, can I apply for indefinite leave to remain? So with regards to our viewers who don't understand this particular immigration route, the FLR simply stands for further leave to remain. FP is a family and private life-based application. So our brother or sister is on a 10-year route to settlement because they have established a family life or a private life in the United Kingdom. They have already completed 5 years of that 10-year settlement route. They are now applying for their third period of leave and will need to apply for one more period to complete the 10 years. Their question is, can they make an application for indefinite leave to remain early at the 7.5-year point? And the answer to that is no. If you are still on the 10-year route to settlement, then you do need to complete your full 10 years. There is a way, a bit late for the individual asking the question, but there is actually a way of being able to achieve settlement early, and that is this. So if an individual applies for further leave to remain on this 10-year route to settlement, generally either because they're a partner of somebody in the UK and they can't leave and establish their family life overseas, either because there are children from another relationship, or there's ill health, or there are other compassionate circumstances which make it difficult, if not impossible, to establish that life overseas, then the Home Office may grant them a 10-year route to settlement in the UK with renewal every 2.5 years. The other way of establishing or gaining leave on this route is by individuals who have had children in the United Kingdom, and those children are either now British citizens or have been here for at least 7 years of their life. Again, the Home Office will then place them on this 10-year route to settlement. What an individual can do or a family can do at that point is the difference between the 5-year route and the 10-year route is usually the ability to meet the financial requirement and the English language requirement of the rules. And most people applying at the start of this process are not able to meet one or both of those. Usually, some people will meet the English language requirement, but they still can't meet the financial requirement. The 18,600 per annum still applies, plus the add-ons if there are more dependents. And so, because usually at that point, the individual or their family are here illegally, they have no right to work, that financial requirement is not met, even if the English language is, which in most cases it is not. Once an individual has been placed on that 10-year route, they do then acquire the right to work. They can study. And so what you can do to speed up this process and to achieve settlement at the 7.5-year mark is to use that first 2.5-year period both to establish yourself financially so that you are able to meet the financial requirements of the rules, and also to learn the English language to the required level, which would be the A2 level. Once an individual's done that, when they come to their first renewal period after the 2.5 years, you would vary your application. So you're still making the FLRFP application, but you are putting in a variation. You are not now applying under the 10-year route to settlement. You are, in fact, now applying under the 5-year route to settlement. You would start your 5 years afresh. So, in essence, you lose 2.5 years, but you still end up to a quicker route to settlement, because after 7.5 years, you then apply for settlement. And that's probably the process that you've heard about in terms of individuals applying for indefinite leave to remain after 7.5 as opposed to the 10 years. But unfortunately, as I say, unless you've already varied, you're not going to be able to do that. And your process would then be longer if you opted to do that now. But if you are just simply on the 10-year route, you can't apply for indefinite leave to remain after 7.5 years. And I hope that answers your question. Another question here, Assalamu alaikum, alaikum assalam. My son applied for a spouse visa. His wife is in Pakistan. He called the Home Office to check the status of his wife's visa. They replied that the visa is being considered, awaiting a decision. After 2 weeks of that email, they asked to pay the immigration surcharge, which he has now paid. What does that mean, and how long do we have to wait for an answer? So the Home Office will deal with spouse applications, applications for leave to remain from overseas within 12 weeks. On the whole, they are still meeting those time frames. And so you would expect to receive a decision within 12 weeks of making the application. Now, in your particular case, you may experience a delay. I'm not entirely sure how you managed to submit an application without paying the immigration surcharge. It's an online application process, and you're not able to submit the application until the immigration surcharge and the online application fee are paid, and then it finalizes the submission. So my concern there would be, how was this application submitted if the immigration surcharge wasn't paid? And so the implication might be, if the application isn't fully paid, it may not be properly under consideration at that stage, and your 12 weeks may start from the point where you have made that payment. But on average, 12 weeks to make a decision on such applications. So hopefully that does answer your question. But if there is a delay, the reason for that is the late payment of the immigration surcharge. Just again, double check that you have paid the application fee and that has been processed as well. Because as I say, usually they are paid together at the point when the application is submitted. Please do continue to send your questions through. We are getting lots of questions, and there's always a point where, unfortunately, there's a cut-off and I can't get through all of them. We are proceeding again to another short break. Continue to tune in with us. Have your questions ready, and inshallah, I will be back in 2 minutes with further details for you. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining me again, and we have a caller on the line, so inshallah we'll proceed straight to that call. Hello, assalamu alaikum.
Hello.
Assalamu alaikum.
Wa alaikum assalam. I have a question regarding my immigration.
Yes, brother, please go ahead.
Status. So basically, my spouse is EU national.
Yes.
I was an overstayer, so we did our Islamic marriage, and then before last year, December, I did my solicitor submit the paper application for EU as a EU spouse.
Yes.
But that application has been refused because the marriage was Islamic.
Yes.
And then we done a settlement scheme, which was before the deadline. Because of the pandemic, I could not register the marriage.
Right.
So my marriage, for the second application, we did a council marriage, and then we submitted for settlement. And that one refused is because the marriage was after December. So now the two application is pending. They give me an appeal right.
Yes.
So I just want to know that I still have to wait for how much chance I have, or is there any other application I have to make?
No, it doesn't. It doesn't sound like there is any other application that you can make, brother. Now, you say that you married before the Islamic marriage was before December 2020. Had you been in a relationship before that, or did you meet quite quickly and then got married?
No, before that, it was from October. Actually, the marriage was last year.
Right, and your relationship started in October of 2020 as well.
Yeah.
Okay. And in respect of, what status does your partner have now?
Pre-settled status.
So your partner has pre-settled status. And when can she achieve her settled status?
She achieved on, I think, before, it's October last year.
So October of last year, 2021, yeah. she could apply for settled status, the permanent residence. Is that right?
No, pre-settled, because she came basically in October.
So, okay, I see.
An Islamic marriage.
Yeah.
And same time, she applied for a pre-settled because she was entitled to.
Okay, so she's around 4 years away from still applying for, or even more, from applying for her settled status. Right, okay. Yeah. So from the information that you're providing me, that there isn't really any other application that you can make. You would need to simply wait for your appeal and present the information as is. You may be able to rely on the fact that you were not able to get married because of the pandemic, that there wasn't the opportunity for you to do that. Had you already provided notice to get married?
No, I already, so basically that was Islamic marriage in October.
Yes. And
then my marriage took place on April. So once I get the certificate, I done the council registered marriage.
Right.
So, and then I applied another application for, the online application.
But they rejected that, yes, because you hadn't got married before December. Yes.
Yeah, because they said because I did give a notice in December, basically before 31st to the council, but because of the government lockdown,
Yes.
it's delayed to April. But that one they didn't consider. They just said based on delayed marriage,
Yes.
your application is refused.
Yes. So had there not, sorry, forgive me, had there not been a lockdown, when would you have got married?
Yeah, so there was that time they relaxed to 6 people.
Right.
So the April, the government then give an announcement that only 6 people can arrange for the marriage.
Yes.
So in that time, we actually once our rules relaxed,
Yes.
then they invited us to marriage.
Right. I mean, I think the only option that you have at the moment, brother, is to go along to your appeal and present your case to the fullest before an immigration judge. And obviously be guided by your solicitor who is familiar with the facts of your case. But that doesn't sound like another application that you can make in the current circumstances. You are exercising the rights that you have based on the information that you've provided me.
Yeah, so it's there. So basically, it's a long time now because it's last year the paper one.
Yeah.
I still in court, and then the pre-settlement one still in appeal. So obviously, I know there is because of the COVID, everything is delayed.
There is.
It's now nearly more than 1 year.
Yeah, and I think appeals at the moment.
Frustrated and worried.
Yeah, no, appeals at the moment are taking about 18 months, so between 12 to 18 months to get before an immigration judge. So unfortunately, you are one of many people that are still waiting in line. You may still be waiting a while yet, but inshallah, you've got that opportunity to go and then present your case. So just wait for the courts to contact you.
Okay. So at the moment I have to, so you're recommending that I have to wait for the...
Yeah, based on the information you've provided, I think that's the only option that you have at this stage. So you would need to be waiting.
Okay. And is there any possibility or, I mean, because the way they are treating, so that's why I'm just a little bit worried. So.
Yeah. I mean, it's difficult to say, as I say, because, inevitably with cases like this, one would need to see all of your papers and a fullest history in terms of your immigration background. So it's difficult for me to say what your chances are without knowing more detail. So I'd say keep in contact with your current solicitor, present your case, and inshallah, good luck with that.
Okay, thank you for your
time, brother. Thank you. Okay, so for the purposes of our viewers, so our brother has made an application to the Home Office to regularise his status. This was under the European transitional arrangements. So essentially, once we left the European Union, there were regulations introduced that enabled people who would be otherwise required to leave. So European nationals who were living in the United Kingdom, because of the free movement arrangements, they then needed to apply for some form of leave and to prove to the Home Office that they were entitled to remain in the United Kingdom. The Home Office introduced a cut-off period, which was the 31st of December 2020. And there were rules surrounding that. And our brother made an application around those rules, but unfortunately, he made an application on the basis that he was a spouse of a European national. He had married a European national and therefore was entitled to remain as their family member. Our brother had only entered into an Islamic marriage, and as most of you will now be familiar from my previous programs, an Islamic marriage is not a valid marriage in the United Kingdom. And so his application was rejected because the marriage was not accepted and valid. He then did register a marriage in the UK jurisdiction and submitted another application. The Home Office case now, however, is that marriage post-dated the deadline of the 31st of December 2020. And so he therefore still doesn't meet the rules and can't meet the rules because he didn't do so previously. Our brother has an appeal, so let's all make dua for him that he is successful in getting through that and is able to regularise his status and move on. But again, this is why early legal advice is so important, to avoid mistakes of this nature, and so that you're not missing opportunities that are available at the point, but then may not be available in the future to you. Moving on to another question. So we have a question from our brother who asks, my son got married to a lady who is deaf and mute. Does she still need to do the A1 English language test to join him from Pakistan? My son is also deaf and mute. And the short answer to that, brother, is, well, no, because the English language test is a listening, speaking, albeit a writing test, but there must be an exemption in place for that, because she can't hear and she can't speak. And so she can't do a test which requires her to speak and listen. And so in those circumstances, one would ask for an exemption. When you fill in the form, you would submit on there the circumstances and why there are circumstances which prevent her from sitting this test, and provide any medical evidence that's required along with that. But inshallah, that should be a fairly straightforward application for you. Moving on to an issue. Moving on to another issue which has arisen repeatedly today. And that is, well, not necessarily today, but a common one where we have had several questions. And that is where simultaneous applications are being made to the Home Office. And by simultaneous applications, I mean more than one application, either at the same time or in short succession of one another. So with regards to simultaneous applications, and I touched upon it earlier with one of our brothers' questions, is what is the impact on an application that's already pending? So I'll give you an example. An individual makes an application under the European Settlement Scheme. That application is still pending with the Home Office, so the Home Office hasn't made a decision, and the person then decides that they are going to make an application under the 10-year settlement route, because they've got a child who was born in the United Kingdom and who's been residing in the UK for at least 7 years of their life. And so that application is now also open to them. What will happen if that person then makes a second application whilst the first one is still pending? And this is really, really important, because we are repeatedly seeing people falling into this trap of receiving advice in relation to one application, then receiving advice in relation to something else, and then trying to make all the applications in one go, and then getting into a very messy legal wrangle. So I am going to proceed to a short break. Inshallah, join me after these 2 minutes, and I'll give you the answer to that question shortly. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. My name is Riffat Hussain. This is the final segment of the show, so please, if you do have questions, send them through as quickly as possible so that I can address them for you. Just before we went to the break, I was discussing, or I had posed a question in relation to simultaneous applications to the Home Office and the impact on the previous application if that happens. Now, there are two ways in which a simultaneous application can be presented. Sometimes individuals will make two applications together. That has happened, and the Home Office does provide guidance in relation to that. If two applications are made at the same time, then the Home Office will generally contact the applicant and ask them which application they intend to pursue. You can't pursue both at the same time. You have to make a decision as to which one. The Home Office will make that contact. They will present the question. If the individual responds and makes a choice, then the Home Office will obviously cancel one and refund any money that needs to be, as long as biometrics haven't been enrolled, and proceed with the other one. If the Home Office attempts to contact the applicant and to ask them the question and they do not respond, the Home Office will cancel both applications. So please make sure that if you are submitting information to the Home Office and providing an email address or contact details, that you are in fact then checking those accounts for any correspondence that you may have received. Don't give an email address that you check once a year and then forget to check it more routinely, because you may miss important correspondence. It's also helpful to check junk box or spam boxes, because most often communication from the Home Office will, certainly in the first couple of instances, land into your junk box or your spam box, and it will only go into your inbox if you mark it as safe. So just be alert to that as well. Don't just check your inbox, just have a quick peek at your junk box as well. So that's if the applications are made together. If the applications are made separately, so an individual makes an application, they've had advice that this is the right application for them, and then later on they discover that there's another route, for example, or their friend made a different type of application and they think they should try that as well, and then they submit a second application. Please be aware that you cannot have two applications with the Home Office, bar for one exception, which I'll come to in a moment. And so what you will essentially be doing is varying your previous application. Again, if I go back to the example I gave earlier, you've made an application for the European settlement scheme for either pre-settled or settled status. You've then been advised that you can apply for the 10-year settlement route under the immigration rules also, but a different appendix, and you make the second application as well. The impact that will have on your pre-settled or settled status application is that will stop, and you will then, the Home Office will then consider the new application, because you have varied your application. So please, again, seek legal advice before making such decisions. You can't go back, particularly if it's, for example, the European applications where deadlines may have passed. You may no longer satisfy the rules. And what you can't be in a position of doing is playing this, ping pong with applications. One day I'll have this one, the next day I'll have that one, and then I'll try this one again because that probably was the right one. It's important to get details correct and then make your application to the Home Office. These processes are difficult enough without adding more complications to them as to which application you're pursuing, when and why, and whether or not you're going to lose your fees on the ones that you have already put in. The exception that I alluded to is the only time you can have two simultaneous applications is where you've got an application pending and then you make a protection application. So an application for protection or a human rights application. In those circumstances, you are then required, you can then have two simultaneous applications at the same time, but that is the only exception. So if you are one of these individuals who have sent questions through saying, I made this application, I then made a further application under a different category, I haven't heard anything back. You probably haven't heard anything back from the first application because you varied it and that's no longer under consideration. So you may want to check that with the Home Office. You may want to check that with your legal representative and decide how it is that you're going to pursue and what options you have left in terms of pursuing any route that you wish to do so. So, inshallah, I hope those do answer your queries, and if there is something else that I've missed in regards to that, then please do come back to me and I will elaborate further. But as I say, it's always better to know what your rights are before randomly sending applications to the Home Office. And again, the impression that creates is a very negative one, in the sense that if you're willing to simply throw lots of different applications at the Home Office, either simultaneously or, you know, when one's been refused, then try a different one and then a different one, it just creates a very negative immigration history. And it gives the impression that you'll try anything just simply to remain in the United Kingdom, which doesn't really help with the assessment of your value to the UK society. So moving on to another question, and probably the final question for this evening. The questioner asked, my son was born outside of the UK when I had indefinite leave to remain. He is now 2 years old. I'm now a British citizen. Can I apply for his British passport straight away? I'm not sure if you're asking whether you can apply for a British passport or whether you're asking about his citizenship. So if you're a British citizen, did you apply for your child's citizenship at the same time? And were they granted? If the answer is yes, then you can proceed to apply for a British passport. If you did not, and your child is not a British citizen, then you may need to register your child as a British citizen before you are able to apply for a British passport for him. So again, it depends very much on the circumstances as to what nationality your child holds at the moment, whether or not your child was part of your application for citizenship, and what it is that you're wanting to apply for now in terms of proceeding with that. So that is your question. That was a brief answer from what I understood from your question. If I have missed anything, then inshallah just drop me another line in the final few moments of this show, and I will try and pick that up. So we have another question here. I want to ask if my son, who is a cancer survivor and has OCD, he's off work, can he not apply for his fiancé visa whilst he's on benefits? And then it says, whilst he's on benefits. So again, it's a similar question to one that I answered earlier. If your son is in receipt of, if your son is in receipt of disability-related benefits, then he is able to apply under the immigration rules. They do have to be disability-related, so personal independence benefits, disability living allowance, which was the predecessor, if he's still on that. If he's simply on benefits such as universal credit because he's not working, etc., then unfortunately that doesn't allow him to apply. That income cannot be taken into consideration to exempt him from the financial requirement. But if he has disability-related benefits, then that should not be a bar to him applying for his fiancée to come to the United Kingdom. Right, so I believe I have got through the majority of questions. If I have missed anything, then please do forgive me. I do try and get through everything that you send through to me as quickly as possible. But there are occasions where I do miss things. If I do come across anything that I have missed or I've not managed to get around to you, then I do always save it to my next show. And to come back to that. So inshallah, do send me another reminder if I haven't got around to your question today. So just another question here. So in terms of the question here, it's in relation to an asylum application and how long they are taking at the moment. This question, unfortunately, again, there is I believe, an over 70,000 case backlog at the moment, with individuals waiting, if not more, of individuals waiting to be interviewed by the Home Office before their applications can be assessed. And even once individuals have been interviewed by the Home Office in relation to their asylum application, there are still significant delays in respect of decisions also. The key, unfortunately, is just to try and stay in touch with your legal representative, who will in turn seek regular updates from the Home Office and will advise you about any further options, either your complaints or, if your case permits, judicial review action or pre-action, certainly, in respect of getting your case moving and getting that decision from the Home Office. We are coming to the final moments of this show. Again, I would like to finish by thanking you all for taking the time to join me, for taking the time to participate, and for your lovely comments that you do send through. They do mean a lot. I do read through them. Inshallah, I will be back next week. Do continue to send your questions through. Feel free to send them through in advance because it allows me to sort through them and get through them in the show as well. Inshallah, I wish you all the best until next week. Join me then. Assalamu alaikum wa rahmatullahi wa barakatuh.